Officer Dade, would you open the courtroom, please?
The state of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning. We're still waiting for one more attorney. Your case, sir. He's going. Fuck this.
Where
We are on the record calling file number 20165-347. The file is entitled Roberts Orthopedics versus Blue Care Network of Michigan and State Farm Mutual Automobile Insurance Company. By notice dated February 9th, this matter is set for pretrial today, March 23rd at 10 o'clock. It's currently 10:31. Your appearances.
Stephen Mammon on behalf of the plaintiff, Your Honor.
Bar number.
P74773.
Matt Zamieski on behalf of defendant State Farm, P74406.
All right. We don't have anybody here from Blue Care Network of Michigan. The default, defendant Blue Care Network of Michigan is hereby entered. Now, in regard to you two, did you make the 2.302A disclosures?
Your Honor, we've talked, counsel and I, about this case. I think this is a case that we're going to end up resolving. There's only a small amount in controversy. We were hoping to see what unfolded today with respect to Blue Care Network, whether they're going to pitch in any money or not. I will follow up with council today. I don't know how the default will affect that. This is one that we're talking about hundreds or dozens of dollars. So that's kind of where we're at. Council, I mean, are you on the same page? I get our conversation correct?
Yeah, I mean, there's not a lot of money owed here, Your Honor. We have spoken briefly. Obviously there's a default now. Know how that affects things, but you know, obviously me and brother counsel will speak and maybe try to resolve this.
So neither one of you, let me make sure I understand this, have complied with the court's order and made it 2.3028 disclosures.
I have not, Your Honor. Was that part of the order that was entered asking us to be here today?
The order that enters you today reads, and I'm quoting, parties shall, language is mandatory, make the MCR 2.3028 disclosures within 21 days of the date of this order. It's the same order that brings you here today.
Okay, Your Honor. No, I have not filed those disclosures. We've discussed the content of them at least, though.
Have you made your disclosures?
No, Your Honor.
Well, gentlemen, what is your understanding of the meaning of the word shall?
You're right, Your Honor. We should have disclosed those. I think we probably got caught up that this was one that we are going to settle.
But you didn't.
No, we'll settle this afternoon if that's.
All right, gentlemen, this is what's going to happen. I'm going to give you an April 27th return date. You will make those disclosures within 10 days of today. And I will enter the default of Blue Care Network having failed to appear. Does April 27th at 10 o'clock work for both of you?
That
We'll
works,
have
Your
wrapped up
Honor.
before then, yeah.
All right. Then let me send out your order, April 27th at 10 o'clock. I'll enter the default of Blue Care since they have failed to appear. And if you guys are able to settle, then so be it. If not, we can get working on this file. Because where we are now, this is now the end of March. I sent this out on February the 9th, and basically nothing's been accomplished.
We'll get it done, Your Honor.
All right, gentlemen, thank you. We'll send
Thank
out.
you, Your Honor.
Let me suggest going forward, I'm not a disc jockey. I don't do requests, I do orders. If those orders are not followed, there are sanctions. I live in a very simple world. April 27th, gentlemen. Thank you for
Thank
coming
you, Your Honor.
Thank you.
off the record. All right, good morning.
Good morning, Your
Good
Honor.
morning.
Let's see who we got. All right, Mr. Reed, who do you have?
I'm here on case number 19176-906.
Okay, anybody here from auto owners? No answer. Moving right along. Back to the waiting room with you, Mr. Reed. I don't have a pair.
Okay,
Okay, Mr. Bedouin, you are here for,
Total healthcare,
are you the plaintiff or defendant?
plaintiff,
Stillman,
yes.
anybody here on that file?
Sharon Powell.
You're Sharon Powell, you are here now? Okay.
Yes, for total health care.
Then we have you both right here. We'll do you guys right now. Let me
Okay.
put other people back into my waiting room. Okay, this is 9:06. What? 830, sorry. All right, we are on the record. We are calling file number 20158-830. This case is entitled Total Healthcare versus Sharon Powell. This appears to be our second pretrial. When we were together on March 2nd, February 2nd, excuse me, the court opened written discovery. Your respective appearances.
Good morning, Your Honor. Sean Bodwine, P71644 on behalf of the plaintiff.
And what is your name, ma'am?
Sharon Powell.
All right, where are we on our discovery? People, we've had discovery open for now more than a month. What has been accomplished?
Well, actually, this is Sharon Powell speaking. I haven't talked to anyone from on behalf of Total Care.
Okay. And Mr. Veteran, what discovery have you done? Or you, let me rephrase this. Since neither one of you apparently have done discovery in the more than a month that we've had since our last pretrial, are either of you intending to do written discovery?
Well, I'm actually trying to see what I need to do. I mean, thought I was going to explain what happened with this, the total health care, insurance. So
We haven't done any discovery and we are not going to.
Okay. So you two are not going to have any discovery. Are you going to do any discovery, ma'am?
now, what does that mean? Like,
Discovery is your opportunity to learn about the claims and defenses of the other side. The court rules provides specific ways that you can do that. The court opened your discovery a month ago.
Okay. See, this is what I'm thinking. I'm coming today to state my case on this whole issue here.
Ma'am, this is a pretrial. And what I'm trying to ask you are whether you intend to do any discovery or not.
I mean, I can talk to him, yes.
That's not what discovery is, ma'am. Discovery of written interrogatories, requests for admissions, and requests for production of documents. Are you going to do any of those things? You just want to have a conversation?
I mean, I guess we could just talk about it because I did write a letter to the court stating what happened with this.
Well, ma'am, first of all, let me make one thing perfectly clear.
Okay.
This is an adversary situation. And so
Okay.
if you want to write a letter to the court, you need to send a copy to the other side. What I'm going to do is I'm going to put you two in a chat room to give you an opportunity to have a conversation. Does that work for you, sir?
Okay.
Yes, Your Honor.
All right, let's try to do that.
Thank you.
All right, good morning. Let's start with Mr. Cox. Why are you darkening my Zoom doorstep today?
Well, good morning, Your Honor. I'm appearing on behalf of Great American against Mollet for a pretrial conference at 11 o'clock.
All right,
Last three digits are, oh my,
847.
847, correct.
That defendant has not appeared as of yet, so I'm going to put you in the waiting room.
Very good.
Mr. Adams? why are
Good
you-
morning, Your Honor.
Good morning, sir. What brings you here?
I'm here representing Sinitra Halliburton in Westlake versus Halliburton.
Okay. Anybody?
And
File.
we have a pretrial today.
Yeah, I understand. All right, Mr. Adams, I don't have your opponent either, so you're off the waiting room as well.
All right, Your Honor.
Mr. Cote, what brings you here today?
Good morning, Your Honor. I'm here on the New Horizon Chiropractic versus City of Detroit, ends in 999.
I think I have a match for you.
All right.
Ms. Oulette, back again? All right. I think I have a match on that file. This is 20165-999, New Horizon Chiropractic versus City of Detroit, your respective appearances.
Good morning, Your Honor. Ian Coote, 73154, on behalf of the plaintiff.
Good morning, Your Honor. Teresa Olet, P72765, appearing on behalf of defendant City of Detroit.
All right, Mr. Coop, Ms. Olet was so anxious she got here our. So, if you guys settled the case, I mean, you're so anxious about it.
We have not settled the case, Your Honor. We've just exchanged our initial disclosures.
Okay,
And it is my understanding from our third-party administrator that there are some bills that are barred. There are still a few remaining outstanding bills, and we have not resolved those yet.
all right.
I
Mr.
agree with all of that.
You agree there's some outstanding bills that you're disputing, but there are some bills that are also barred apparently by the 1-year back rule.
Yep, that's
Okay.
correct.
All right, so let's do this. Let me give you guys another date. And then in the meantime, you're going to submit a stipulated order that the following bills are barred by the 1-year back rule, date and amount. So we know exactly what we're arguing about.
Okay.
That work for everybody?
That's fine for me, Your Honor.
All right,
Yes,
does
sir.
April 27th at 11 o'clock work for both of you?
That'll work for me, Your Honor.
Ms. Oulette?
Yes, that will work for me, and I'll be sure to show up at 11 and
You
not
can always
10,
come
like
early.
I've done twice. I've done that to
I
you.
know this thing. She's really
I just wanna
anxious
show
to go.
Early.
All
Either
right.
I get no notice or I come early. There's no in between, apparently.
It's in between for you, huh? All right, let's do this. Let's make sure, since you're the plaintiff here, Mr. Coop, you're responsible for making sure I get that stipulated order, striking the claims for the specified cases, obligations.
All
We
right.
have a provider, data service, and the amount. So we won't have any arguments about what we are still arguing about. That work for everybody?
Fair enough. That works for me, Your Honor.
April 27th at 11 o'clock, and make sure I have your stipulated order striking those claims prior to that time.
Yes, sir.
Fair enough, Your Honor.
Anything else we've accomplished today?
No.
Nothing for me.
Okay, then thank you both very much. I'll send you out an order and have a great day.
Thank
Thank
you.
you, Your Honor. See you, Teresa.
Bye. No more appearances. Bye.
Not today. Ms. Richter, good morning.
Good morning, Your Honor.
What brings you here today?
I'm here on a status conference for dynamic MRI versus auto owners.
I have Mr. Reed. We can do yours next.
Thank you.
I seem to have both sides on file number 19176-906, Dynamic MRI versus Auto Owners Insurance. Your respective appearances.
Attorney Arnold Reed II on behalf of the plaintiff, P 84142.
Good morning, Your Honor. Leslie Richter on behalf of defendant auto owners.
For some reason, I do not have your file. Let me call and have that brought over. Hang on for just a second, please. All right, my file is on my way. Where are you guys on this file?
Well, Your Honor, today was supposed to be settlement discussions before setting a time to have parties with their authorities present, and it's not settled. I don't think it's going to settle at this point. Defendant has filed 5 motions in this case, and plaintiff has filed 3, which was the entry of default judgment, then to substitute homeowners for auto owners, and they wouldn't even agree to that, and then a motion to compel certain discovery and depositions for Karen Winters and Susan Smiley. Now, Your Honor, you made us withdraw these motions for depositions because discovery was closed, even though the request had gone out long before, and they should have produced their adjuster for depositions.
Well, let's stop right here. This is the district court. How would you have discovery in the district court, Mr. Reed?
Well, if we've had,
How do you have discovery in the district court, Mr. Reed?
I believe the parties have stipulated it. We've had discovery from them. I would have to assume that because we have discovery from them that we've answered, and we've served discovery on them that they have.
Court open written discovery. Depositions are a different matter, Mr. Reed.
So we haven't done that. We wanted to do that deposition, and you wouldn't allow us. But regardless of that, homeowners / auto owners has spent a ton of money needlessly trying to follow our client, spying on them, including whether or not she got her change back from McDonald's, ordering IMEs, which haven't been produced to date. And they've been doing a ton of stuff. We have tried to make several offers to them, which they did not respond to until our last appearance. We made an offer on February 26, 2020, and on October 8th, 2020. They only responded after our last appearance, and they want plaintiff to accept 11.4% after 2 years of litigation. So at this point, I don't believe we're going to be able to resolve this matter, Your Honor.
Okay, Ms. Richter, what do you want to tell me?
We've done an offer of judgment. My client has already paid for these MRIs. We did a offer of judgment to pay additional monies in an attempt to try to settle this case. At this point, maybe it's just best to give us a trial date.
Well, the problem with that, Ms. Richter, is that a trial date is an empty gesture.
Is an empty what, sir?
An empty gesture. Have you heard of COVID-19?
I'm very familiar with COVID-19.
That's our problem.
Yes.
I can't very well threaten you with an empty gun that everybody knows is empty.
I don't know. I'm going to trial next month. I have no idea what's going on, Your Honor. I mean, I get trial dates all the time, whether they're going or not. I'm just an attorney. I'm not a judge. I have no idea. I'm not privy.
Well, let me ask you this. Have you guys considered facilitating the case?
No, that's probably a good idea.
Mr. Reed?
I'm not necessarily opposed to facilitation, but I don't believe honestly that it would be fruitful. We've already made 2 offers, which haven't gotten much traction. At this point, I don't see what facilitation would do other than just give us more dates. I would ask for a trial date, Your Honor. And I know that, like you just discussed, COVID-19, this and that, and a third. Give us a stay if the court is so inclined until juries are being seated. Once juries are being seated, we can try this matter.
Well, if you are both determined that you're ready and you're not going to be able to resolve the case, then it's time for jury books.
It's time for jury what?
Jury books.
Jury books?
Yeah, the jury instructions, copies, with all those things that you have to provide. So before I have you do all of that, I'm going to give you one more date. But if you're not able to do it, I'm going to get you jury books, and then we'll just be in a hold until we get to a point where you're able to do jury trials again, which I got to tell you, I don't think is going to be this year.
Okay.
I really don't. You guys, you watch the news every evening. You see what's happening with Michigan's case of 97% in the last 3 weeks. Does that sound to you like it's moving in the right direction?
I try to watch the news. It's just too depressing.
Yeah.
That's probably a good strategy.
Yeah.
No, it's very, very, I just watched last night. My son goes to school in Colorado. What happened in Boulder? It's just.
Yeah, there's not much good news. Your son wasn't involved in that, was he?
No, but it's just, it hits close to home.
Sure.
It's horrible. I mean, it's horrible anytime, anywhere. You can't even go to a grocery store now without worried about getting gunned down.
We've lost our collective minds.
Yes, we have.
And the thing that bothers me, I don't see, we had the stress of the Great Recession, in which a lot of people never recovered. Then we got this COVID, and we're just having these are mental health breakdowns in my judgment.
Yes.
I mean, domestic violence is up everywhere. Road rage shootings are up everywhere. This is mental health breakdown on a societal basis. And I just don't see how we get out of this. I really don't. But anyway, I'm going to have you guys back on April 27th at 11 o'clock. Does that work for both of you?
Yes, Your Honor.
April 27th at what time, sir?
11 o'clock.
Thank you, Your Honor.
Now, here's what I want you to do in the meantime.
Okay. Should we use the same sign-in number for the Zoom?
Yes.
Okay.
Consider facilitation. And the other thing is that we have an offer of judgment filed on behalf of
defendant
here. It might be time for a counter offer of judgment or something in terms of plaintiff. Because here's the bottom line. Before I have you spend all the time and money to generate the jury books, let's see if we can't resolve the fine. Because ultimately, like I told you, I don't see how we're going to try a case this year. I really don't. So, talk about facilitation. Consider a counter offer of judgment, Mr. Reed, so we can at least get ourselves inside of some kind of range. Well, I think once we get inside the range, I think a facilitation will help you. But again, that's up to you guys. So April 27th at 11 o'clock, we'll try this again. Anything else we can do today?
April 27th at 11?
Yes,
Okay. Thank you very much, Your Honor.
Thank you, and be safe.
Bye-bye.
Take care. Be well.
Okay, we're off the record.
Nice to meet you.
Good to
Well-
see you, Ms. Richter.
I can't get out.
I'll let you go. I'll
Okay.
remove you.
Okay.
Okay, Mr. Bedouin is back.
Yes.
Where is,
She might be still in the breakout room. I don't know if she could get out by herself or not. So.
okay, well, let me close the room then. That'll make it easier for her.
Hello.
Hello, okay. I think I have you both back now.
Okay.
We are back on the record on case number 2015880, Total Healthcare versus Sylvia Powell. Your respective appearances, please.
Sharon Powell.
Sharon Powell, excuse me.
Good morning, Your Honor.
That's okay.
Sean Bodine, P71644 on behalf of plaintiff.
Okay, you guys had a chance to talk in the breakout room. Were you able to resolve the file?
We were not at this time.
Okay, then I want to ask you again, both, whether you've told me, Mr. Bedouin, you don't anticipate doing any written discovery. Did I get that right?
Yes, Your Honor.
And Ms. Powell, are you going to do any written discovery? Because if you're not, I'll close it and just give you another date. It seems to me that's where we're going here.
I think the best thing to do is to close it and give us another date.
All right, discovery is now closed. I'll give you an April 27th pretrial date. Anyone who wants to file any dispositive motions, you should do so immediately.
Okay.
I'll send you out a notice, and I'll talk to you again April 27th at 11 o'clock.
Thank you.
Thank you both. Have a nice day.
You too.
You too. Bye-bye.
Okay. Mr. Cox, you are here on Great American Insurance. Mr. Adams, you are here on Westlake versus Halliburton. Is
Yes.
that right?
Yes, Your Honor.
The problem I have, gentlemen, is I have two lawyers, two different cases, but I don't have a pair yet. So I'll send you back to the waiting room. And at 11:31 to 11:32 or so, we will dismiss or default. The other side doesn't show up.
Thank
Okay?
you, Your Honor.
Thank you. We are on the record calling file number 20167-622, Westlake Services LLC versus Sinatra Halliburton. By notice dated February 22nd, 2021. This matter set for pretrial today, March 23rd at 11 o'clock. It's currently 11:31. Your appearance, sir.
Daryl Adams appearing on behalf of the defendant, Sinatra Halliburton, Your Honor.
The bar number.
54185.
Sir, this matter is scheduled for hearing at 11 o'clock. The plaintiff has failed to appear. No good cause of that failure having been shown. This matter is dismissed without prejudice. We'll send out a copy of the order, sir.
Thank you, Your Honor.
Thank you, sir. Enjoy your day. Be safe.
You too.
We're off the record. We are on the record calling file number 21147-847. That file is entitled Great American Insurance versus Patricia Mollett. By a notice dated February 22nd, 2021, this matter is set for pretrial today, March 23rd at 11 o'clock. It's currently 11:32. Your appearance.
Good morning, Your Honor. May it please the court, Keith Cox of Ingber and Winters on behalf of the plaintiff, P59146.
Mr. Cox, this matter was scheduled for hearing at 11 o'clock. You have appeared on behalf of the plaintiff. The defendant has failed to appear. I have in the file your proposed default judgment. I will simply enter that default judgment that you submitted.
That would be great, Judge.
All right,
Thank you very
all
much.
done then. Thank you for coming in. We are off the record. And that concludes the docket.